Welcome to You and the Law, a Chicago Bar Association production that provides information on various legal and policy matters of public interest. I'm Mike Alkaraki, a partner at Leahy, Hoste Alkaraki, where I represent plaintiffs in cases of personal injury, medical negligence, products liability, and wrongful death. I'm also an adjunct professor at Loyola Law here in the city and a member of the Chicago Bar Association, where I've served on the board of managers. On this installment, we're going to explore antitrust and competition laws and how they promote democracy. With us are Spencer Waller, who serves as the Justice John Paul Stevens Chair in Competition Law and as the Director of the Institute for Consumer Antitrust Studies at Loyola Law, and Pamela Taylor, an attorney at Jones Day, who represents global industry leaders in antitrust matters, including those related to mergers and acquisitions. Welcome to the program.
Thank you.
Thank you, Michael.
All right, so I provided just a very brief introduction for both of you, and I think there's probably a lot more that you can share with us so that our viewers have some idea of all that you bring to the table. So I'd like to ask you each to provide a little bit more background. Feel free to, if you want to, share any particular experience, including, recently before we got started, we were hearing about some of your legal work and roles. Feel free to share as much as you like. Professor Waller, why don't you get us started?
Sure. I've been teaching at Loyola since 2000. Before that, I taught at Brooklyn Law School, and before that, I practiced for 8 years, split roughly between the government, where I was in the antitrust division, doing the kind of work we're going to talk about today. I also did organized crime cases. I also put in 3 years with a firm when I got the teaching bug. And then I should just point out, last year, in 2022, I was on leave from Loyola, working as a senior advisor at the Federal Trade Commission on some of the stuff we're going to talk about today, but I'm here in my personal capacity, and I don't speak for the agency, and I can only talk about publicly available information on that, and I'm thrilled to be here.
Thank you very much for being here. And I'll also point out that Professor Waller, incidentally, was my professor back in the day at Loyola, so I'm really happy that you're with us. And Ms. Taylor, if you could please provide us with some of your background and expertise.
Sure. I really started being an antitrust lawyer when I went to the Federal Trade Commission and worked in one of the merger shops, which is one of the divisions there that reviews mergers and acquisitions and tries to figure out whether a corporate combination is likely to result in less competition. So I did that for about 5 years, and then I returned to private practice in Chicago. And since then, my practice has been really the same, but from the other side of the table. Now I help companies get their transactions cleared through the antitrust process, and I provide them with advice on how to comply with the antitrust laws in their businesses where they may have some questions about what the law requires of them. It's great to be here today with you, Michael, and with my old friend, Professor Waller.
Thank you. Thank you both for being here. Okay, so I'd like to start with the foundations and purposes of antitrust law and perhaps like the most basic terms. And I'll share just a very simple kind of concept that lay people or non-lawyers might understand right away, which is that I think you can tell me if it's not fair to say this, but I think a fair way to think about antitrust law is it promotes competition among market players, commercial market players, with the expectation that that will drive innovation, benefit consumers through choice, efficiencies, lower costs, and it just kind of embraces the policy of healthy competition, as opposed to the other side of it would be perhaps monopolization, price fixing, and all the bad things that come along with that for consumers. So that's my very basic sort of overview for the general public. But if each of you can share some nuances there, or correct me if I've said anything that can use clarification. And either one you can take.
I think you got that essentially right. I mean, the goal of the antitrust laws have been around for over 100 years, and they were put in place by Congress during the era of the big railroad monopolies. And the goal has always been to protect the American public from abuse by dominant firms, either because they are so big that they can harm competition and consumers by their very bigness, or because they've agreed with a competitor to do something that harms the economy, like raise prices or cut back on production. So the driving goal and the underlying rationale is competition is what the American economy is about, and the laws are at bottom designed to protect that.
Great, thank you.
I would just add, that it's kind of a fluke. It's called antitrust law. It's not really worth getting into the details, but it is the law of competition. There's similar laws in about 140 other countries. They are directly referred to as competition law. And in our country, there are three big buckets of antitrust law. One is the part of the laws that prohibit agreements between firms, like price fixing and other cartel behavior. And that's part of the Sherman Act from 1890 that Pamela was talking about. The other part of the Sherman Act prohibits monopolization and attempted monopolization, and those issues are playing out in our courtrooms this week as the United States has a civil case going on against Google to change their behavior and or maybe break them up, but that's the kind of thing that the law covers. And then the area that Pamela has focused on is the third area where the law is concerned with mergers that may tend to either substantially lessen competition or could lead to a monopoly. So those are the three areas that cover most of what we do in antitrust and what the rest of the world calls competition law.
Great, thank you. You both mentioned the Sherman Antitrust Act, which like you said, is over 100 years old, from I believe about 1890. There was a reference there to railroad, and I think Standard Oil was one of the, breaking up Standard Oil was part of what, if I'm not mistaken, gave rise to the Sherman Antitrust Act. Is that accurate?
It was one of the first cases brought of importance after the passage of the law, and the Supreme Court in 1911 did authorize breaking it up. They spoke in such vague language about when they would and wouldn't do that kind of thing that Congress reacted with horror and passed both a law that provided some more details called the Clayton Act, and it also created the FTC, where I was privileged to serve for a year, as an expert agency to assist in litigating and advising businesses.
Got it. And Clayton and FTC would have been both in early 1900s, correct?
Both in 1914.
Both in 1914. Okay. And we can get into them with a little more detail, but my understanding is that both Clayton and FTC, and you alluded to this in your own words too, fill in some gaps and provide some guidance on exactly what, in areas the Sherman Antitrust Act may have been vague or not provided guidance. Is that fair? Or was that?
No, that sounds fair to me. Pamela, you may have a different perspective on it.
Okay, great. And what are, and we'll get into some cases, including before we got started, we talked a little bit about the Google trial, which I think is underway right now. Who are the enforcement agencies, and what are the mechanisms for the antitrust laws?
Spencer, you want me to start there?
Sure, go ahead.
So we have two federal antitrust agencies. The Department of Justice has an antitrust division. And as Professor Waller mentioned, there's the Federal Trade Commission, which is an independent agency, not part of the executive branch. The head of the Department of Justice is appointed by the president, and the head of the antitrust division is also in the executive branch, and the Federal Trade Commission is an independent agency. As a matter of practice, I'm not sure that makes a huge amount of difference, in the courts or in the everyday practice of antitrust law. The states also, the state attorney generals, most states have an antitrust section within their state attorney general's office. And most states have antitrust statutes that are mostly equivalent to the federal statutes, with a couple of exceptions. But often when you see federal enforcement, you also see state involvement. In Illinois, the Attorney General in Illinois is very active in the antitrust area and is often joining federal actions. And interestingly, in the Google case, part of that case, or a separate case, has been brought by some state attorney generals against Google. So we've seen increasing activity by the state attorneys general over the past 20 years, and really there's a kind of growing sense at the state level that there's a role for the attorney generals to play to protect the citizens of their states from, abuses under the antitrust laws.
And then the only thing I would add is, in addition, from the very get-go, from 1890s, there's always been a private right of action where people, individuals and businesses, if they've been injured in their business or property because of an antitrust violation, they can sue for triple damages plus attorney's fees and costs. And it's one of the rare areas of the law where you can sue for multiple damages, and it's designed to create an incentive for people who've been harmed to be able to take care of their business in court if they can prove their case, regardless of what the government chooses to do or not to do in a particular matter. And the only thing I would observe about that is these are almost always cases for money damages. They're not the cases where you're trying to break up or change a Microsoft or a Standard Oil, or it tends to be people who are harmed by price fixing, and sometimes competitors who are harmed by the unfair business practices of a dominant firm of some kind.
Well, let's Spencer, I'd like to stay with you for a moment on that and talk about if we can talk a little bit about the Google case, because it's been the case against Google right now that I believe the trial is underway, because we've made a few references to it, and it would probably be a good time to provide a little exposition or background for that.
Well, sure. This is kind of the Super Bowl of antitrust. And in recent memory, the last time the U.S. government was in court challenging a major tech firm under Section 2 of the Sherman Act, the monopolization, was Microsoft, which is about 25 years ago. Right now, the case, as Pamela was talking about, was brought by the Justice Department Antitrust Division, and then 12 or 13 states. I don't remember the full list anymore. But they basically are making two claims: that Google is a monopoly with respect to search and search advertising, and that they've maintained their monopoly through a variety of unfair and harmful practices beyond what you can call honest competition. One example that I think is fairly clear factually to understand is that Google has over the years paid huge amounts of money, like in the 10 billion with a B dollar range, to be the exclusive or default setting for search on every device that Apple makes, and they license because they license the Android technology to other cell phone manufacturers. It comes with that default, and so the facts aren't in a great deal of dispute. This isn't going to be the world's most exciting trial. It's in front of a judge. It's not in front of a jury. There are no surprise witnesses, and the facts, as I understand them, are largely agreed upon. But the real issue is going to be the legal significance of it. Google claims that for a variety of reasons, you can always switch and use other devices for search. That's true. The question is, how often does it happen? And what are the reasonable options that consumers have when they're doing general search, or advertisers who are doing paid to be on a search ad? And then the real question is, are these things normal things that you do, or is this behavior that harms competition, goes beyond the legitimate needs of Google? And it's not really not disputing the value of Google's product. It's a good product. The case is not about how they got or achieved their power. It's about what they've done, if anything, illegal to maintain that power.
Yeah, that's a really good point, that the antitrust laws don't actually make it illegal to be a monopolist if you've invented Google or a better mousetrap of any kind, and customers love your product, and as a consequence, you have 98% market share because what you sell or offer is so superior. That's not illegal. It's what you do after you've achieved that share of greatness with your power to maintain your monopoly that can get you into legal trouble. And that's what the government, I think, was going to have to prove, that they took unlawful means to maintain their monopoly in the forms of agreement or otherwise.
And I think the law would certainly cover if you achieved your monopoly through heinous means, like burning your competitor's factory down or something. That's not at stake in this case, but it would certainly be covered by the law.
For sure. But,
So it sounds like, and you both mentioned that there does not necessarily appear to be any kind of serious material factual dispute, but this is a matter of legal philosophy. It sounds like what the rule is, what the approach is to this, and what kind what kind of activities are offensive to our sensibilities in that regard?
Yeah, and so far the government has used, it's only in the second week of trial. I think they expect it to go 8 or 10 weeks. And again, the judge will rule on this. There's no jury. But the government's been focusing on two things. Two different categories of evidence. One are the internal documents that Google has, where people in their own company talk about their own power, their own dominance sometimes is being used. So, there are some hot documents where they talk about things that are helpful to the government's case. And then the other kind of evidence, I guess two other kinds, is there'll be some testimony that we expect from competitors and customers who can talk about the harms that this lack of choice has created. And then there'll be some expert testimony. Some of it will be fairly wonky economists. Some of it are business professors and psychologists who can talk about why the default setting on your phone is the one that tends to stick, even though if you know what you're doing and you have enough time that, yes, you can change it. But the average person doesn't.
Sure.
I haven't. I should. I haven't gotten around to doing it because it involves too much work.
Sure. If you think about all the different markets that Google can be perceived as operating in, everything from search, for example, I mean, even YouTube, I believe, is a
Yep.
Google company, and just the the real estate they sort of take up on the internet is huge and not always obvious. But and I don't know if this is going to be evidence in the trial or not. But this kind of conduct, for example, a group called Foundum, which is a vertical search, and I'm not attuned enough to the dynamics of search tools to be able to articulate the differences. But it's a difference in kind, and a different type of searching, a different type of product than Google. I think people close to it would all acknowledge. But one of the things Google has done is, Foundum says that Google has demoted, if you search on Google for a competitor, that competitor like Foundum might be, incidentally, not found because they're buried on page, 15 or 20 or 25. So there is sort of a new world here of activities companies can engage in, and there's it's a little bit meta in the sense that they can, they're operating kind of, on higher dimensions, within their own industry.
Right. And then, there's the question of, if Google can preferentially rank results, does that end up excluding, others who could enter into any of the businesses Google is engaged in?
Right. Let's switch gears a little bit because, as we discussed at the beginning, time does move pretty fast, and I want to at least spend a decent amount of time on the FTC proposed ban on non-compete clauses. And Professor Waller, if you want to take that one.
Yeah. So I'll try to do this without getting too much into the weeds. The Federal Trade Commission was was created in 1914. It's 5 commissioners. It's bipartisan in the sense that only 3 can be of the president's party. Once some certain confirmation hearings are finishing up in Congress, it'll be back to 3 Democrats and 2 Republicans. There were some vacancies. And the basic law that the FTC enforces is a little bit different than what we've been talking about. And that law prohibits unfair methods of competition. And that's the antitrust powers that the FTC has. And then there's a separate set of laws that prohibit unfair and deceptive acts and practices. That's all the unfair advertising and straight up fraud. And everyone agrees that the unfair methods of competition go beyond the literal language of the Sherman Act and the Clayton Act and the other antitrust laws. And then the dispute comes in as to how far does it go. And so a couple of things happened over the last year or two, part of which occurred when I was working there as a senior advisor, and most of it's happened after I left. The FTC adopted by a party line vote of 3-1 a new statement for the first time that comprehensively defined what unfair methods of competition are and the circumstances under which the commission would be likely to take action if you found certain things. And it's just kind of amazing that there's just never been such a thing in the 100+ years that they've been around. There had been a short, simple 1-page statement in 2015 that said, sure, our superpowers go a little beyond those of the regular antitrust laws, But the old statement, we more or less view this as just like the regular antitrust laws. That's not what this new statement says, and it explains in detail how much further it goes. And that's a policy statement. It's an internal policy statement that is soft law, but not yet adopted in any court decision. And so in January of this year, the FTC announced a proposed rule, administrative rule, that said that non-compete clauses in employment contracts would be considered an unfair method of competition. The proposal is 200 and some pages. It explains the legal basis, the economic basis, and some of the harms that these clauses do in the economy. They propose to ban non-compete clauses in employment contracts, except when they are in the context of the purchase or sale of a business, or like the formation or dissolution of a partnership, whether that's a law firm partnership, a ad firm, or something else like that. In the legal context, it's a little complicated because non-compete clauses are barred by our rules of professional responsibility. But this rule would ban across on a federal level, across a wide swath of the economy. And in fairness, a bunch of important states have banned or limited these clauses already. California, most prominently, has banned them. Illinois has banned them if you make above a certain amount. If you make below a certain amount of money. So there's different state approaches. This would create a uniform federal rule if adopted. It's been put out for public comment. The FTC has received 26,000 comments. And I'm kind of happy I'm not there to have to go through all of them, and then write the final version of the rule will at some point be put up for a vote by the commission, and then enacted into law. And then I imagine it will get into the courts in short order for reasons that Pamela we can talk about if you want.
Right. Sure. Yeah. I mean, 26,000 comments. One of my jobs a long, long time ago, and all junior staffers at the FTC do this. I think this is still true. When something goes out for notice and comment rulemaking, and you get comments, the commission responds to them. So somebody has to formulate a response to all the comments. So
you can do it by categories. You don't have to do each one individually.
They can say, 14,000 commenters said this is a great idea. Something like that. But it's still a big job, no matter how many buckets you can put the comments into. So who's to say when we'll have a final rule, or if there will even be substantial enough revisions so that the commission will decide there might need to be another public comment period. But Michael, go ahead.
Oh, I was just wondering, are there any particular interests that are pushing back against this? Like, who may be opposing?
Sure. Many companies impose non-compete agreements on certain kinds of employees. It's very common sales employees, right? We don't want you to take your book of business that you generated at our company across the street to our main competitor and use that to steal business from us. Very common. As Spencer said, many states have been, legislating against some of those types of agreements, but I think many types of companies will object because this would be a very easy way for former employees to essentially take what is the company's intellectual property or know-how or expertise and use it against them immediately.
Now, that has been the concern expressed by the Chamber of Commerce, the Wall Street Journal, a variety of business groups and firms. This proposal does not in any way change the laws about trade secrets or the ability for a firm to protect itself that way. What is in the public record already, and there's a long way to go on this rule, is the FTC has brought a few cases about non-competes that have been settled. So you have a consent decree where the parties have settled and the judge has approved. So you have those, and they've arisen in a couple of settings that are interesting and show what the potential harms are. One is a firm that is sort of an employment agency for home healthcare workers and like security guards. And their non-competes were so broad that it was like if you left their employment, and you're talking about people who made at or just above the minimum wage. And if you left, you were banned for 2 years and a span of 200 miles. And the economic harm for that is dramatic. You really effectively can't get a pay raise from your own firm because you can't leave. And you can't get a pay raise from somebody else because you have this clause. And in the past, maybe someone, but not these people, can challenge it in court and find that it's overbroad. This rule and so this case was brought that in the context of this industry, this was an unfair method of competition. And there's no admission of guilt, but the company was prepared to settle and in fact got rid of this. And I think that there'll be positive benefits for some people who are working very, very hard and don't make that much money, and they can better their lives. There's another way. The FTC, another case that it brought shortly after the rule was announced, but this is just a one-on-one case of FTC versus 3 firms in the glass container industry that's centered in upstate New York. 3 firms have most of the industry. They're good paying jobs, but they use non-competes for everyone from the janitor to the CEO. And so again, the FTC brought a case alleging this was an unfair method of competition, and the firms chose to settle without admitting anything, but agreeing to get rid of these top to bottom non-competes where people, again, are kind of specialized and do have some legit training, but nowhere to go in the old days because of the restrictive rules that the companies applied. So those are 2 examples that give you a sense of the harms that the FTC is focusing on. And then it's a separate thing about whether you end up with a final rule that is economy-wide.
Great. Thanks very much. And we're running a little tight on time. And so I just wanted to ask this question and get some feedback on this, and we can close up. I was wondering, we hear a lot about these big institutional investment firms that have horizontal stock ownership. BlackRock, State Street, Vanguard are the principal ones we hear about. I know it's probably very complex to dig into this in detail, but to the extent that these entities have ownership, and oftentimes significant ownerships in competing companies across multiple industries, does that raise antitrust concerns, or is that somehow not within the scope of those rules?
Well, Michael, there is a one statute, Section 8 of the Clayton Act, that directly addresses the role of board members and when they can and when they can't serve on the boards of competitors. And that's a pretty bright line statute, and it's designed to prevent the flow of information between competitors via their board members. And it's been enforced, and it's being enforced, more, I would say, more aggressively now than in the past. But in terms of minority ownership, I think it's really difficult to parse that because of the many restrictions on the power that minority owners can really have over the companies they've invested in. I don't know that I would say you could have a bright line rule about it, but I think maybe Spencer might have a different view.
It's an important issue. We don't have a lot of cases about this, but what you're talking about, Michael, is a situation where you could have 3 or 4 hedge funds or private equity groups that each own 5 or 10% of all the airlines, and then all the other ones own 5% or 10% of all the airlines, and you have a potential for what is in the best interest of their investors is not in the best interest of the public, because you could imagine a world. I don't have access to any information one way or another. You could imagine a world where you'd make more money if you cut back on flights and raise prices, but you'd have less competition. That's the concern.
Right, and that is the principal antitrust concern that gave rise to the Sherman Act to begin with, right?
It's about the misuse of power, and it takes different formats and different stages of the economy. Back in the day, you're right, it was railroads and oil companies, and then it became steel companies and higher tech things, and in the 90s, and it was Microsoft, and now you're talking about both financial companies and more of the tech giants that we read about in the papers every day.
Right. Okay. Well, that's what we've got. We're probably a little bit over time, so I appreciate you both very much for participating in this and sharing your wisdom, expertise, and insights. And of course, thanks to our viewers for tuning into this installment of View in the Law.